Good evening, ladies and gentlemen. Charles, thank you very much for that very kind introduction. And I don't think I've seen Charles since the election, and it's good to catch up again. And he reminded me of that legislation, which was over 10 years ago, when he was a minister and I'd come into to Parliament. And I remember him berating the Grand Mufti of Damascus a few years ago, and he left him in no doubt as to what the Grand Mufti should be doing in Syria, and he's probably now doing it for the wrong reasons. And the last time I saw you, this is name dropping, was with the Dalai Lama, where in Parliament, the Dalai Lama came to the Commons once, and I was, because I'm a member of the Tibet Society, very supportive of the Dalai Lama, I was seconded to accompany the Dalai Lama from David Cameron's office when he was leader of the opposition to take him to Westminster Hall, a journey that takes about 4 or 5 minutes to walk. It took about 45 minutes to get there because the Dalai Lama spoke to everybody, the security guards, the police, the cleaning ladies, and everybody. And Charles came up and wanted to shake his hand as everybody else did. And you'd met him before, I think, and reminded him. And he remembered because he then patted your stomach. It was sort of Buddha-like, or Buddhism meets Dalai Lama. So we got a good photo out of it, I think, at the time. But anyway, thank you very much for those kind words and for inviting me. And I'm really pleased to be here. And I think it's a really interesting series that Charles has put together in the Too Difficult box. And certainly I'm following in the footsteps of some very eminent parliamentarians who are eminently more experienced than me to address such an audience. And as Charles said, it's good to see some old friends here as well, who across parties have worked with me on child protection issues over many, many years. And I think it's really interesting and appropriate to apply the thorny title of this Too Difficult box to child protection. I think a subject on which my recent offerings, along with other former ministers from the Department for Education, all of whom were cleared out to make space at the last reshuffle, and we all appeared in front of the Education Select Committee the week before last as a sort of exit interview exercise, which never happens in politics, and it was actually rather interesting. It was quite cathartic for some of us as well, but it was very entertaining for the media, who seemed to get quite a lot of headlines out of it, which have struck a raw nerve with the Department for Education. However, you could say, on the back of that the whole issue of child protection has become a too difficult box now with the current DfE management, because ever since Jimmy Savile all of a sudden became a household name for rather different reasons, the Department for Education seems to have been on radio silence. But what I want to do is just to draw on my experiences, partly as the Minister for Children from 2010 until the reshuffle in September, but probably even more so, as Charles says, over effectively 9 years where I held the brief for children's social care and child protection in opposition, a period which saw a lot of changes and all too high-profile examples of failure and tragedy in protecting children. Now, my bottom line is that as far as I'm concerned, I considered nothing in child protection as a too difficult box. And I always endeavoured to apply the prying eyes of parliamentary scrutiny wherever I could, and certainly to places where my party, the Conservative Party in particular, had not exactly enjoyed a reputation for being such trailblazers previously. I spent more time with ordinary frontline social workers, I think, than was perhaps healthy, perhaps was expected of a Conservative politician. I spent a week during my time as Minister actually being a social worker out on the front line with other professionals in Stockport, and really interesting and useful it was for informing the work that I was doing. I spent another few days as an independent reviewing officer in Leeds. I met almost monthly groups of children who were in foster care, children who were in residential care homes, recent care leavers, and children who'd been adopted. I met their birth parents, their foster and adoptive parents, their prospective adoptive parents. I spent time with gangs and young people who'd spent most of their lives institutionalised through the care system, young offender institutes or prison, and had survived. And most poignantly, I think, I met a number of young victims of child sexual exploitation, traumatised in some of the most despicable ways imaginable, and their families whose own suffering is actually much underappreciated. I slept on floors and sofas in tower blocks, getting to know what makes some of our most chaotic families tick, and I adopted one of the families with multiple problems into whose dysfunctional lives the government is crucially seeking to intervene earlier through its Families with Multiple Problems programme now. So you could say that I've been around a bit. You certainly couldn't say that I needed to get out more. So I think the best way to approach the task in hand today is to start by reeling off some of the perceived wisdoms surrounding child protection, which too often in the past have been in a too difficult box. Firstly, better child protection results from more child protection legislation and more child protection regulations guiding those whose job is to protect children, which leads on to leading on from which is only people versed in child protection can actually protect children, and social workers in particular need directing very closely. Or better data collection protects children, especially when it involves a large, shiny, new, expensive computer system. Or children are far safer now than they were when Victoria Climbié met her tragic fate back in February 2000. Or that serious case reviews are a useful tool for assessing what went wrong when children are harmed or killed, and they are better left unpublished and shared with only a very few exclusive audience. Or that local safeguarding children's boards are satisfactory. Or that child sexual exploitation is something that only really happens on the other side of town to other sorts of people. Or that least said the better about cultural sensitivities concerning child sexual abusers, because child sexual exploitation is not culturally segmented. And when it comes to child abuse involving witchcraft and other dark arts, perhaps we should just leave it to the Home Office. Children in the care system are always going to underperform, so we better just accept that. Or there's no such thing as institutionalised child snatching. Or when placing children in care, either for fostering or adoption, finding the right ethnic match should be a deal breaker. And most confusingly, in my perceived wisdoms that I challenged, we need to take more children into care, or we need to take fewer children into care. That the appropriate levels of children are getting adopted, and in any case we can leave it all up to the courts and local authorities to take the right decisions about whether children should be adopted and in a timely manner. And most topically, well, Jimmy Savile was, well, just Jimmy. Now, on that last point, if there is one compensation from the extraordinary revelations about the once semi-beatified, spangly, shell-suited celebrity, it is that the media profile and public consciousness of child sexual abuse has never been higher over the last few months. Ironic, then, that the Department of Government, which is responsible for taking the lead on child protection, the DfE, and on child sexual exploitation especially, appears to have adopted radio silence over the last 6 months, but that's just me being lazy, narcissistic, and incompetent, as apparently was said. Now let me deal with those issues individually. The first high-profile and probably most notorious case that I dealt with as Shadow Children's Minister, responsible at the time, was that of Victoria Climbié, a name that we are all familiar with, and what turned out to be the most expensive and probably the most comprehensive child protection investigation subsequently in British history. The response to the chilling events that led up to that young girl's death on February the 25th, 2000, and the subsequent trial of her two torturers, met with a familiar public refrain and clamour. How could we have let this happen? Something must be done, heads must roll. We need a comprehensive review to ensure that this can never happen again. Well, of course, it has happened again and again. And actually much more than just the more recent high-profile cases of baby Peter Connolly or Kyra Ishak would lead people to believe. One of the less jolly ways that I used to start the week as Children's Minister was to receive a Monday morning rundown from safeguarding officials at the DfE about the latest cases of children abused, tortured and often killed at the hands of their parents or carers or mum's newly acquired boyfriend, the state of the subsequent legal proceedings and the progress or not of the resulting serious case reviews. A great way to start your Mondays. But the most common manifestation of the many comprehensive reviews I referred to as my third cri de coeur was usually adding a few hundred extra pages to the instruction manual, or specifically Working Together, which was the Bible of child safeguarding. Now, when we came into government, we inherited a working together manual which well ran to over 700 pages. It was infinitely prescriptive about how professionally trained social workers and others should manage their working days in pursuance of their job. It specified timescales, and it spawned processes and bureaucracy which meant too many social workers were spending too much of their time in front of computer screens, filling out 50 pages of ICS forms for every child, largely detached from the specific requirements of that child. Little wonder that a survey by Unison at the time estimated that many social workers were spending up to 80% of their time chained to a desk in front of their computer screens rather than out at the sharp end, engaging with the vulnerable families and children that they thought they were there to look after as social workers and certainly went into the profession to do. On my many visits to see local authorities, I saw bustling social worker offices with little sign of the clients of the social workers themselves. And I remember one visit to Birmingham, which still has serious problems and is in intervention. And I went to visit a social worker office in Birmingham, and I went with me one of the directors from the social work department and a senior counsellor, not the cabinet member for children, but a senior counsellor. And one of the social workers came up to me and she said, "Did you know that we aren't allowed mobile phones by the council? And that the council don't pay if they use their own mobile phones when they go out on their rounds, expecting them to go into some very dangerous situations. Some places where even the police wouldn't go." I found that extraordinary. But what was more extraordinary was the fact that neither the director with me or the senior counsellor knew that. There was a serious disconnect between the front line, the social workers going out into dangerous, challenging conditions, and the people who ran the council, both politically and from an officer level, back at the town hall. And I think this was a classic example of where well-intentioned legislation and over-regulation was actually getting in the way of good child protection, where social workers were constantly having to look over their shoulders to check what it said in the manual rather than trust their professional instincts to do what they thought best for that child in their care. It manifested itself, I think, in the response of one director of children's services to one of the more high-profile child deaths, which I won't name, when he said that all the local authorities' social workers had done their job properly. All procedures had been complied with, and no one would be resigning. No mention of the fact that a baby boy had died in horrific circumstances on his watch. That was a secondary issue, almost, to the fact that everybody was complying with the expectations of their job. We had lost trust in social workers. We had failed to trust in their professionalism. And as a result, they had lost confidence almost in themselves. They were damned if they did and damned if they didn't, in the eyes of the press, particularly the Mail. Many good and experienced social workers voted with their feet and left the profession. A shortage of new ones coming through meant that the entry requirements for university social work courses fell and the pass mark requirements fell with it. That was unsustainable for the social work profession, but also unsustainable for good child protection. So that's why we sought to try to start to help reverse that trend when we were in opposition with the publication of the No More Blame Game report in 2007, on which June Thorburn very helpfully participated, as a result of the excellent work of the Commission of Child Social Work, which I chaired. Now, that detailed piece of work heavily informed the policy of the DFE today, as did the Back to the Frontline policy paper, which we produced just before the election, and ultimately was why the first review launched by the Department for Education after the 2010 election was not about the curriculum, not about the future of the exam system or schools. It was about the direction of social work in the form of Eileen Munro's Review of Child Protection, launched by Eileen and me in June 2010. And a fantastic piece of work that was, and I think it got very wide acclaim. A child-centred system, as it was called. Now, I sought to institute its recommendations, not by just a knee-jerk response by saying, yes, we must institute all of that, as so often governments do, but instead by setting up a group of practitioners from health, from the police, from the social work profession, from education, to translate it into meaningful actions across a wide range of professionals involved in child protection. And I hope that those 15 main recommendations of Eileen's will be taken forward urgently by my successor, and I look forward to a slimmed-down version of Working Together, which will probably be fewer than 70 pages long, rather than over 700, being published soon. Now, implementing Eileen's 15 main recommendations is not just a question of changing procedures, it's actually about changing mindsets. It's about having realistic expectations of how well professionals can protect children and young people from people, often very devious people, who would do them harm. And it's about reversing a defensive culture that focuses on compliance with targets and rules instead of whether services are actually providing effective help. And in short, I think that the Munro approach is all about trusting social workers to make the wrong decision. Hopefully not too often, but child protection is not an exact science, and I would rather that social workers use their professional nous on the ground, eyeballing the people they're there to protect, and occasionally come to the wrong conclusion than simply do what it said in the manual, whether or not they felt it was actually the right thing to do that was going to achieve the right outcome for that particular child or family. So the too difficult box is that more regulation meant more safety. I think it meant the reverse. The government, with the help of Professor Munro, is now handling that box, a bit too slowly, but it is. Yet for some on the front line, it does remain a too difficult box. How can they possibly do their job without adhering to strict and universal assessment timetables, however artificial they actually are in practice? The box is far from ticked, but the pen, I think, will soon be in the hands of the professionals to take back their destiny into their own hands. We have to trust the social workers again. But overreacting, over-regulation has been the hallmark of so much children's legislation over the last 15 years, and I mean so much. The Children's Schools and Families Act 2010, the Children and Young Persons Act 2008, the Safeguarding Vulnerable Groups Act 2006, the Children and Adoption Act 2006, the Children Act 2004, the Adoption and Children Act 2002, the Care Standards Act 2000, the Care Leavers Act 2000, Protection of Children Act 1999, and I was on most of those bills. And it has been a tsunami of well-intentioned legislation and regulations flowing from it. But it's not necessarily been about quality, it has been more about quantity, and therein lies the problem. Now, too often, opposing some of those bills outright was a too difficult box to face. And I plead guilty in many cases too. How could you possibly vote against a bill or regulation that came in the wake of the dreadful Victoria Climbié tragedy? How could we have let this happen? Something must be done, heads must roll. We need a comprehensive review to ensure that this can never happen again. Try fighting against that reaction. Well, occasionally we did take a stand against the juggernaut of child protection measures, however, perhaps none more high profile than voting against the establishment of Contact Point, the massive, shiny computer database with details of all 11 million children across the country. How can we possibly be against that? A common feature of all these tragedies has been the lack of data sharing. A computer database will surely protect children. You surely could not but put a tick in that box. Well, therein lay the problem. It's not a computer database that protects children. It's the professionals who use the data. Beyond that, of course, it is the public themselves, armed with information about what to look out for and why we all have a duty of vigilance. The problem, I contend, was not so much the lack of data sharing, it was why professionals are not instinctively sharing data much better in the first place. And even more importantly, when they do have that data, why is someone not picking up the ball and running with it much more effectively? The Contact Point, I think, was the greatest and most expensive knee-jerk reaction in this whole field, and I'm very happy to defend that if we have that in questions later on. It was never going to do everything that many people thought it would. It was becoming a security nightmare with access to nearly 400,000 people, and still had no answers for a registrar at 9 p.m. on a Friday night, for example, confronted by a mum at A&E with a young child with suspicious injuries. And I believe that the £235 million spent on it so far could have been much more effectively spent on upgrading the social work profession itself. So I switched it off in August 2010. The world didn't fall in. Not too hot to handle, quite tepid, in fact. I think that was the right thing to do. So when we came into power in 2010 and asked ourselves, are children safer now than they were over 10 years ago when Victoria Climbié met her tragic death? I think it was almost impossible to be able to answer yes. Certainly we had more rules, more laws in place, as I've said. Certainly social workers were under much more of a spotlight to deliver and a lot of pressure with it. The public were more aware of child abuse, at least as something that happened on the other side of town, perhaps. But how could we tell if they were safer? By all accounts, just as many children were still dying at the hands of their carers or parents. But to say, of course, they are not safer would have been too difficult. And part of the problem, of course, was the lack of transparency when something did go wrong. Of course, Herbert Laming produced his extensive 405-page report on Victoria Climbié, and details of the baby Peter Connolly death were plastered all over the media. But the main learning tool, the serious case reviews produced for hundreds of incidents, were not routinely published. The redacted contents were not made available to many people at all, just an exclusive and limited club. But of course it would be far too difficult to publish them. Personal details would get into the public domain. Professionals would be fingered. The main players would resile from giving the full picture for fear of the ramifications. Best left unpublished and heavily redacted for good measure, and a short 10-page executive summary, which may or may not bear any resemblance to the actual facts, would suffice. Well, we weren't having that either. And despite a huge backlash at the time from across the children's sector and vested interests, we gave an undertaking to put a tick in that difficult box. And so from June 2010, all serious case reviews were to be published in full, subject to protecting anonymity, to appropriate redaction, and only if they could not be shown to be a realistic threat to the welfare of a surviving child or siblings in a case. We also, of course, said that retrospectively would seek to publish the SCRs for Peter Connolly, for Kyra Ishak, the Edlington torture case, and the bizarre story of Shannon Matthews in Kirklees. With the exception of the last, all of these have now been published, and I've expressed my concerns about publishing the last one, contrary to what you read on the Spectator blog. I was the one always pressing for publication, and when we did, the world didn't fall in. Hopefully more people were able to learn more lessons, and we could have a proper debate about why children were still not safe enough in whatever part of the country it happened. There is a problem, of course, because the number of serious case reviews now being commissioned has decreased, and I don't believe that's a reflection of a decline in cases meriting serious case reviews. And I've always said that actually I think we may need legislation to regularise this and a strong steer from the centre about what should be published, as at the moment the DfE has no legal powers to force a local Safeguarding Children board actually to commission a serious case review in the first place. We also need more urgently to perfect an alternative process for serious case reviews, which are still a far from adequate learning tool, but at least we have filled in the box and we can have a legitimate debate about why they are inadequate and what they should be telling us, professionals and the public, who need reassurance that child protection is in the right hands, and the male headlines about caricatured, failing, sandal-wearing social workers may actually be unworthy of further scrutiny. Now, my second major subject heading under the too difficult box is the subject of child sexual exploitation. I think for too long the issue of child sexual exploitation has received too little attention. The system has not done enough to support victims and their families. The courts have not done enough to support traumatised young witnesses. And perhaps most worryingly, too many local areas have failed to uncover the true extent of child sexual exploitation in their communities. Some say, well, it actually doesn't happen here. And as I said when I launched the government's Child Sexual Exploitation Action Plan back in November 2011, the piece of work I'm most proud of from my time at the DfE, this country has now to wake up to the fact that its children are being sexually abused in far greater numbers than was ever imagined. People think of this as a problem that affects only certain sections of society. It doesn't. It could be happening in any community, in any part of the country, in urban areas, in rural areas. And we know the daughter or son of the local businessman is just as vulnerable as a girl or boy living in care. In the words of one young survivor who I met, we know abusers will have anybody. Doctors' children, lawyers' children, anybody. But that all started to change when the police in Derby prosecuted a group of British Pakistani men who'd been systematically abusing children across the north of England. The prosecution stuck and it hit all the headlines, in some cases for the wrong reasons, pandering to the wrong extremist political agendas. But several other cases followed, and of course we have the case of 9 men currently going on in Oxford, the subject of even more heinous charges, and there are plenty more to follow. That in many respects is actually a sign of success, because it means that the police are taking cases more seriously, more people are coming forward with evidence, and the courts are making the charges stick. And in the action plan, we identified 4 key stages where we needed better intervention on child sex exploitation. First, raising awareness of this issue with young people, their parents, and with professionals. Secondly, taking effective multi-agency action against exploitation and helping children who are victims to escape it. Thirdly, securing robust prosecutions and improving court processes to ensure support for victims and their families, particularly where you have the obscene situation where a 15-year-old girl will be giving evidence in front of 7 different barristers, acting for 7 different defendants, re-traumatised by being forced to go through some really ghastly experiences that may have happened to her. That still needs to improve. And fourthly, helping children and families who are caught up in sexual exploitation getting their lives back on track. And it may take a long time to do that. Now, the progress report on the action plan, which I published last July, contains some really real, practical examples of actual progress in identifying and rescuing victims and alerting them to avoid the dangers in the first place. And in my time at the department, I met many victims of child sexual exploitation, girls and boys, some as young as 11, and listened to their harrowing tales. But almost as traumatic were the stories of what the families themselves had been put through, where those children were still living at home. Whilst the victims were disproportionately in the care system, the greater number were actually living at home with their families. I heard from parents whose children had been taken into the clutches of these gangs, repeatedly sexually abused for cheap vodka and drugs and all sorts of other things. The parents had found out, with the help of local agencies, they'd rescued their daughter, and their house had been firebombed by the pimp who resented the fact that they'd rescued their daughter. The extraordinary brass neck of some of these people acting with impunity and the traumatic effect it had on families for many years to come is quite mind-blowing. And this isn't going on in just rough parts of rough towns. It's happening in suburbs and in rural areas as well. And I'm not emphasising the reality of it. But of course, the real underlying too difficult box here is the fact that this was a phenomenon not just happening to other people's kids on the other side of town in northern metropolitan boroughs, but it was taking place in every city, every town, every rural area, and to and with every social class and indeed ethnic background. But that last detail had been the deal breaker. There was no doubt that reports of child sexual exploitation being committed by largely Pakistani British gangs of men was not being acted on because of cultural sensitivities. It really was a too difficult box for some police, as many officers, particularly in Lancashire, where much of this went on, will now admit to. Coming hard on the heels of the Derby case, much of the coverage of the equally shocking case in Rochdale has focused on the fact that the perpetrators were British Pakistani men and the victims were white teenage girls. Clearly, it's important that we don't shy away from difficult issues around culture. And that case raised very troubling questions about the attitude of the perpetrators towards white girls in that case. Nothing is gained by shying away from that, and yet undoubtedly it had deterred the authorities from pursuing this as vigorously in the past as they should, and it was largely down to support groups such as Safe and Sound, a fantastic charity in Derby, and the redoubtable Sheila Taylor, who ran it, that the perpetrators were eventually brought to justice. But that case asks all of us to take a long, hard look at the society in which these crimes occurred and kept occurring. Where were the support networks which should have protected these young girls from abuse? Where were the people and institutions, from parents to police, from friends to core professionals, which should have provided them with stability and guidance and stopped them falling prey to men who lured them with fast food and cheap vodka? But I'd like to stress that the uncomfortable questions about abuse should not be directed only at the Pakistani community, of course not. The majority of those in jail for child sex offences in this country are white men. I can take you to networks of white abusers in rural Cornwall, to communities practising witchcraft-inspired abuse in East London. The point is that child sexual abuse happens in many shapes and forms in all parts of the country and in all communities. It is a serious and particularly nasty crime against vulnerable children, and we need the appropriate tools to tackle it whenever and in whatever form it manifests itself. Culturally appropriate, but not culturally blind. For some, I think that it is still in the too difficult box, but I think that mindset is changing, and I hope changing rapidly. In the case of witchcraft practices involving child abuse, this is a very murky area which we are only just beginning to understand, and where the inclination in the past has perhaps been not even to go near that box. The tragic death of 15-year-old Christy Bamu, cruelly killed on Christmas Day in 2010 by his sister's partner, and the graphic detail with which the press reported his fatal injuries struck a raw nerve with many. Christy's killer, Eric Bikubi, subjected the youngster and his siblings to a brutally horrific ordeal based on the belief that they brought kindoke, or witchcraft, to his home in East London. He was savagely attacked over 3 days with knives, sticks, metal bars, ceramic floor tiles, bottles, a hammer and chisel, with his ordeal so severe that he begged to die. His sister, who should have protected him, was also party to the abuse, and this highlighted just how toxic abuse carried out in the name of witchcraft can be. Scotland Yard at the time said it had investigated 83 cases involving abuse resulting from ritualistic or faith-based belief over the last 10 years, but starkly warned that it continues to remain a hidden and underreported crime, making it all the more difficult to protect potential victims from harm. And in August last year, I launched a national action plan to tackle child abuse linked to faith or belief, drawn up in partnership with faith leaders, charities, the Metropolitan Police, and other statutory partners. And it brought together bodies that are instrumental in cutting through the wall of silence surrounding ritual child abuse. And it really can be a wall of silence, silence born out of fear in close-knit communities. And the key challenge now is to gain the buy-in of those communities themselves to come forward and report cases of abuse and neglect, particularly where those closed communities may scare them off contacting the authorities. That's a really difficult box to tick. Finally, let me just touch on one other aspect of child protection which occupied a large part of my brief, and that's children in the care system. And I think what has appeared as the government's disproportionate focus on adoption, though that was never intended. As I've always said, the yawning gap between the outcomes for children in the care system and their peer group, lucky enough to spend their childhoods with their own birth parents, remains a scandal. Evidenced most starkly by the A star to C achievement levels in GCSE, for 14.6% of kids in care achieving those 5 good GCSEs against 58.1% of the equivalent population overall. That is a yawning gap and a stark warning about the amount of work that is still to be done. But inevitably, children taken into care are damaged and already at a disadvantage when it comes to experiencing a normal childhood. And when so many of them spend so much time in the care system being moved from pillar to post, the continuity of a stable education, above all, is one of the first things to suffer. That's why it's been so important to discriminate positively, something I'm not normally in favour of, but in favour of children in care and leaving care in the education system through automatic qualification for the pupil premium, for example, through the higher education bursary replacement for EMA, which automatically qualifies for children in the care system, and so on. But in the past, the too difficult box has been whether we should be taking more children into care routinely because of neglect and poor parenting skills, or whether we should be concentrating on keeping birth families together regardless. And I think the pendulum has, of course, swung in favour of the former, particularly post-baby P, but arguably largely out of a knee-jerk risk aversion mentality, and subsequently numbers coming to care continue to rise. So I think we are far from solving that conundrum, but what I do know is that whether we take more children into care or fewer children into care, we need to concentrate on taking the right children into care and at the right time. And I hope that freeing up the time of social workers to devote more of their professional capacity to eyeballing the subjects of their cases rather than their cases notes will help that. And if we do not do this, the cries of the Christopher Bookers of this world, who believe that all social workers are modern-day versions of the child catcher in Chitty Chitty Bang Bang, beholden to politically correct-driven targets, will hold even more sway, and even more of my constituents will write to me on the basis of what he said in the Sunday Telegraph this particular week. One of the things I learned the hard way in my 2.5 years as minister is that the simple act of changing the law or ministers overhauling regulations doesn't automatically mean that anything will change. I personally went through all the regulations governing fostering and adoption. I rewrote the manual. I wrote repeatedly to directors of children's services across the country, to adoption panels, to judges. I narcissistically stalked the TV studios and media outlets to put my case, then sat back and waited for it all to change. But still the adoption numbers drifted, still the complaints from foster carers that they always had to second-guess the permission of the social worker before agreeing a sleepover came thick and fast, and still the exasperation from prospective adopters that they were being given the "don't call us, we'll call you" routine from local authorities, or that judges and adoption panels were taking years ping-ponging a child's future backwards and forwards, but delay was a price worth paying in order to get a quality placement. And of course, the subject of ethnic matching constantly reared its head, however much I tried to focus on the many other practicalities standing in the way of getting more adopters coming forward to adopt more children. And a few months ago, of course, it became a gift for the tabloids when UKIP supporting foster carers in Rotherham had their charges swiftly removed just in time for the by-election. The truth that has been too difficult, and which is also at variance with the government's localism agenda and with the move to trust the professionals that I set out at the outset, is that to make a significant culture shift, you do actually need to intervene centrally and strongly, mobilising the disinfecting sunlight of transparency. You have to challenge the box and everything inside it. Hence, the government, I think, is now quite rightly changing the law around putting default time limits on care cases, reducing the status of cultural matching considerations in adoptions and for fostering, breaking down the recruitment barriers between local authority and voluntary agencies, and laying bare the laggards through sophisticated adoption scorecards to reveal the real picture in local authorities. This must not be mutually exclusive over the significant work that we have to do for the 90% plus of children in the care system for whom adoption will never be the appropriate way forward, and in particular the work around the quality of residential children's homes and the people who work in them is something I set in place last summer, which is very important. And in particular, another too difficult box has been the blind eye that has been turned to the near 50% of children placed far away from home in residential children's homes that are effectively in child protection war zones in places like East Kent, where a disproportionate number of children are residing in children's homes where sex offender hostels and other dangerous individuals are present in the very same street. Again, changing the rules has done little to change practice, and that box needs to be well and truly addressed now, and I hope that the findings of the working parties that I set up will report soon and start to do just that. And finally, of course, the longest standing, too difficult box of all, that quirky, spangly, shell-suited celebrities like Jimmy Savile deserved beatification more than vilification, because that was just Jimmy, wasn't it? As I started off by saying, if there is one compensation by the whole extraordinary revelations about Savile, it's that the profile of child sex abuse has never been higher in the media and in the public consciousness, ironically at a time when inexplicably the responsible department at the DfE has never been quieter. If there is a major downside, it's been the focus on celebrity abusers, whether they be in the world of show business, politics, or religion, whereas we know that the vast majority of abusers are non-entities within the family of the victim, or taxi drivers, or kebab shop owners, or computer programmers, or whatever. So my final too difficult box is my call for an overarching inquiry into the whole history of child abuse, going back to the 60s, 70s, 80s, looking at what went wrong across a wide range of scenarios, entertainment, care homes, the church, schools. When did things change and why? How much has actually changed, and have the victims finally had the opportunity to have their say and have their stories taken seriously and outstanding perpetrators brought to justice. Only then do I think that the public will start to be assured that our institutions today have robust child protection practices in place to tackle modern-day Jimmy Saviles or the murderers of Victoria Climbié and Peter Connolly and their like. I'm not holding my breath, but at least I think we've not just ticked a lot of boxes in our journey this far rather than avoided them, but we've actually started to achieve meaningful and effective change. And to do that for vulnerable children must surely be one of the most noble and worthwhile things that a minister and a government can do. Thank you very much.